Good morning, friends. My name is Himanshu Parekh. I am a tax partner with BBSR & Co, which is a affiliate of KPMG. Pleasure to be here this morning and address all of you on this very interesting topic of royalties, fees for technical services and service fee in the context of software industry. When we talk about the software industry, it is this industry which has been responsible for making India's name prominent on the world map. The industry is today almost about $100 billion worth. Yesterday in the papers I was reading TCS is now amongst the top 10 companies globally. That's a matter of pride for all of us. Having said which, unfortunately on the tax front, things are not so good as far as the industry is concerned, be it indirect taxes, be it direct taxes. Talk about indirect taxes, this issue of levy of service tax and VAT both on the same software transaction has been a major pain point for the industry. Talk about income tax related issues, a host of tax controversies, be it in the context of claim of tax holiday under section 10A, 10B, be it various issues surrounding withholding tax on a variety of payments, PE related issues and whatnot. And to add to the woes of the industry, wherever the industry has succeeded in any litigation so far, the government has been more than fast to make retrospective amendments in the law to overcome all those favorable decisions issued by courts. And therefore the need for the hour as far as the industry is concerned is for the government to clarify the tax laws. There should be abundant clarity in tax laws, and the need for the hour is to have a non-adversarial tax regime in India. So with this background, let us now dive into the presentation for today's topic. So the topic being tax issues in the context of royalty, fee for technical services and service fee vis-a-vis the software industry. So if we talk about taxation of royalties and fees for technical services, let me just first provide a broad overview of the provisions of Income Tax Act as well as the tax treaties governing taxation of royalties and fee for technical services in India. If we talk about the provisions of the Income Tax Act, based on section 5 and 9 of the Income Tax Act, where any non-resident earns any income by way of royalty or fee for technical services, either if that income is received or deemed to be received in India, or if that income accrues or arises or is deemed to accrue or arise in India, such income shall be liable to tax in India. Now the mode of taxation and the rate at which such income will be taxed would be governed by the provisions of section 115A and section 44DA of the Income Tax Act. Let me now provide you a broad overview of a typical royalty article of various tax treaties which India enters into. So we have article 12(1) which specifies that normally speaking royalty will be taxable in the state of residence of the person earning the royalty. Article 12(2) provides that such royalty will also be taxed in the state of source, but at a rate not exceeding a particular percentage, which in the case of India ranges generally between 10 to 15% as per the treaties. Article 12(3) provides a definition of the term royalty and fee for technical services. Article 12(4) typically provides that where the royalty or FTS is effectively connected with a PE of the recipient of the income, let's say in India, such royalty or FTS will be taxed in accordance with Article 7 and not in accordance with Article 12. Article 12(5) thereafter provides the place where royalty or FTS place where it arises or is deemed to arise. And 12(6) provides for certain adjustments in respect of certain related party transactions. Let us look at the definition of the term royalty under the Income Tax Act. So the definition is provided in explanation 2 to section 916. It says that any consideration including lump sum consideration for transfer of all or any rights in respect of any patent, invention, model, design, secret formula or process or trademark would amount to royalty, and these are all rights as we call it as IP rights. Similarly, transfer of all or any rights in respect of copyright, literary, artistic or scientific work, including films or videotapes or tapes for use in connection with TV or radio broadcasting, will similarly amount to royalty. Similarly, any consideration for imparting of any information concerning the working of or the use of the IP, which we saw in the first box, or imparting of information concerning any technical, industrial, commercial or scientific knowledge, experience or skill would also amount to royalty. And again, any consideration for use of any IP or for right to use any industrial, commercial or scientific equipment would also amount to royalty. Apart from that, if there is any service which is rendered in connection with any of the rights which we just discussed earlier, even the payment towards those services will amount to royalty. There are two specific exclusions from the definition of royalty under the Income Tax Act. The first one is that if any income is derived by the IP owner, let's say from transfer of the IP which results in a capital gain in the hands of the IP owner, such capital gain is outside the purview of the definition of royalty. Similarly, any income arising to a person from the sale, distribution or exhibition of cinematographic films is again outside the purview of definition of royalties. Let's look at two other provisions which are relevant in the context of our discussion today. The first one is second proviso to section 916. What this provides for is that where a person receives any lump sum payment in respect of computer software which is supplied by a non-resident manufacturer along with computer or computer based equipment, if such a equipment is supplied under a scheme approved by the Government of India, the payment in respect of such equipment which has software embedded in it will not amount to royalty. And the question which arises is that if a software was to be provided dehors of the equipment, that is without the equipment and independent of the equipment, would it mean therefore that having regard to this second proviso, such payment will automatically amount to royalty? And we shall look at that in greater detail in one of the subsequent slides. Let us now look at subsection 1A of section 115A. What it states is that where the royalty referred to in subsection 1 clause B is in consideration for the transfer of all or any rights including granting of a license in respect of copyright in any book to an Indian concern or in respect of any computer software to a person resident in India, the provisions of subsection 1 shall apply in such a case in relation to such royalty subject to certain modifications. Now see the underlined portion. It talks about copyright in a book on the one hand, on the other hand it talks about consideration in respect of computer software. There the words used are not copyright of a software, and this has a certain weightage, this has a certain implication. We shall see that in the subsequent slides. Now there was immense litigation on the point as to whether software payments would amount to royalty or not in the past. We had several high court and tribunal decisions taking contradictory positions thereon. With a view to overcome all those favorable decisions, the government amended the law with retrospective effect right from 1st June 1976 to specifically cover payments for the use or right to use software within the definition of royalty. This is by virtue of adding explanation 4 to section 916. Similarly, there was immense litigation on whether connectivity payments would amount to royalty. Connectivity payments as in payments towards transponder hire charges or telecom connectivity, bandwidth charges. There again we had contradictory decisions. With a view to overcome all those favorable decisions, explanation 5 and 6 got inserted into the act, and by virtue of explanation 6 it is now provided that, as we saw earlier, payment for use of process amounts to royalty, and the question is what is the meaning of the word process. Now the meaning of the word process is provided in this explanation 6 so as to say that any use or right to use transmission by satellite or cable or optic fiber or any other similar technology would amount to a payment for the use of process and therefore royalty, irrespective of whether this process is a secret process or not. We had again litigation surrounding the point as to when can a payment be said to be a payment for use of equipment. As we saw earlier in the definition, payment for use of equipment amounts to royalty. But when will a payment amount to a payment for use of equipment? There were a host of judicial precedents thereon. In most of the cases, courts had taken a view that unless the customer who makes the payment has a physical access to that equipment or control over that equipment, it cannot be said to be a payment for the use of equipment and therefore cannot amount to royalty. With a view to overcome all those decisions, again explanation 5 got inserted in section 916 to say that the test of possession or control of the equipment or location of the equipment will be all irrelevant factors while determining whether the payment is royalty or not. Thus, the expanded definition of royalty by virtue of insertion of explanation 4, 5 and 6 now would specifically cover within its purview software payments, bandwidth charges, transponder hire charges and connectivity charges. And what is interesting to now note is, while under the Income Tax Act, all these payments will clearly amount to royalty. The question is, what would be the tax treatment thereof under the tax treaties? And we shall look at that in greater detail as we proceed. Let us quickly look at the definition of royalty under the OECD Model Convention. The OECD model states that any payment of any kind received as a consideration for the use of or right to use copyright of literary, artistic or scientific work, including cinematograph films, or any payment for use or right to use patent, trademark, design, model, plan, secret formula or process would amount to royalty. Similarly, any payment which is a consideration for information concerning industrial, commercial or scientific experience would amount to royalty. Let us now look at the definition of royalty under the UN Model Convention, and here the definition is very much similar to the definition of the OECD Model Convention except for two specific aspects. The first one being any payment in respect of right to use copyright of films or tapes used for radio or TV broadcasting is specifically covered in the definition of royalty in the UN Model Convention, which is not to be found in the OECD Model Convention. Similarly, payment for the use of industrial, commercial or scientific equipment again finds a mention in the UN Model Convention, but not so in the OECD Model Convention. Other than this, the definition is identical to that of the OECD Model Convention. Let us quickly look at the definition of the term fee for technical services under the Income Tax Act. Section 917 read with explanation 2 there too provides the definition of FTS, so as to say that consideration for rendering managerial, technical or consultancy services, including provision of services of technical or other personnel, would amount to fee for technical services. However, there are two exclusions therefrom. The first one being that any payment towards consideration for construction, assembly, mining or a like project will not amount to FTS. Similarly, any payment which is liable to be taxed under the head salaries will not amount to FTS. So, these are the two exclusions from the definition of FTS, and a similar definition of the term FTS is to be found in most of the tax treaties which India has entered into, barring a few tax treaties where we have a much narrower concept of FTS, like for example the India-US tax treaty and a few other tax treaties. So, let us look at the definition of FTS under the India-US tax treaty. Now, the India-US treaty does not refer to the words fee for technical services, it in turn refers to the expression fee for included services, but is nothing but fee for technical service only. So, what it says is fees for included services means payments of any kind to any person in consideration for the rendering of any technical or consultancy services, including the provision of services of technical or other personnel, if such services, clause A, if such services are ancillary and subsidiary to the application or enjoyment of right, property or information for which a payment described in para 3 is received. Now, what do we mean by this? Para 3 basically article 12.3 refers to royalty payments. So, let us say you acquired some IP for which you made a royalty payment, and in connection with that royalty payment some incidental services are also rendered. So, such services, if they are ancillary and subsidiary to the provision of such IP which is subject to tax as royalties, then such services will amount to fee for included services under clause A, 12.4a of the India-US treaty. Now, we move to clause B. What it says is any consideration provided paid for rendering services which make available technical knowledge, experience, skill, know-how or processes, or consist of the development and transfer of technical plan or technical design, such consideration again will amount to fee for included services. And this is something which is very important for the purpose of our today's discussion. So, there are two things out here: whether the services make available certain technical knowledge, skill, know-how, experience or process to the service recipient, or whether the services amount to or result in transfer of a technical plan or technical design developed by the service provider to the service recipient. Now, this entire concept of make available, as you may well be aware, has been subject to protracted litigation in India. What is this concept of make available? There is an explanation of that to be found in the protocol or the memorandum of understanding to the India-US tax treaty, and the MOU clarifies that services would be considered to be made available to the recipient of the service by the service provider if the person acquiring the service is enabled to apply the technology contained therein. And mere requirement of a technical input being required by the person providing the service. So let's say just because the service is technical in nature and it requires certain technical inputs at the end of the service provider, that by itself will not make this a case of technology or technical services being made available by the service recipient to the service, by the service provider to the service recipient. Similarly, use of any product which embodies technology cannot be considered to be made to make technology available. Now essentially what all this means is that very simply, what is envisaged in the concept of make available is that there should be a transmission of knowledge, know-how or some technology from the service provider to the service recipient in such a manner that the service recipient himself then is able to provide such service independently on his own without recourse to service provider in the future. So if there is transmission of such know-how or knowledge or technology by the service provider to the service recipient, whereby making the service recipient himself an expert in that field, then only will such payment amount to fee for included services, not otherwise. Now the MOU to the treaty further provides certain examples of typical categories of services that generally involve either the development and transfer of a technical plan or technical design or making technology available. And one of the specific examples, see look at point number 3, computer software development is specifically classified as one of the areas in which technology can be made available, and therefore it may amount to fee for included services in the facts of a particular case. Now the concept of make available apart from India US treaty is to be found in various other treaties like the treaty with UK, Singapore, Australia, Canada, Netherlands and so on. Let us move on further. Let us look at the correct. I think it is a good defense. So for a service to fall within the purview of fee for included services, two conditions need to be satisfied. Firstly, the service should be technical service, and secondly it should make available technology. So in the first instance, if we are able to substantiate that the service is not technical service at all, then there is no need to refer to make available at all, you straight away get out of the definition of fee for included services. Let us look at the basis of taxation of royalties or fees for technical service under the provisions of the Act. Now depending on whether the royalty or FTS is paid by an Indian concern or a government to the non-resident, or depending upon whether the royalty or FTS is effectively connected with a PE of the non-resident in India, or depending upon whether the agreement between the resident and non-resident is it approved by the central government or included in the industrial policy or not, the rate of tax can vary from either 25% on gross basis under section 115A or 42% including surcharge and cess, of course, 42% on a net basis under the provisions of 44DA. So that is broadly the tax regime as far as royalties FTS in India are concerned. Very interestingly, if a royalty or FTS is paid by one non-resident to another non-resident and assume that that royalty or FTS is taxable in India, then such a payment will be subject to tax in India on a net income basis at 42% and not at 25% on gross basis. Again, looking at the taxation of royalty or fee for technical services under the tax treaties which India has entered into, if the royalty or FTS is effectively connected with a PE of the non-resident, let us say in India, then the taxation shall be on a net income basis as per Article 7 of the treaty. Whereas if the royalty or FTS is not connected with any PE of the non-resident in India, then it will be taxed on a gross basis as per Article 12. We have this concept of what we call as the most favored nation clause in various treaties which India has entered into, and that is a concept which is an important concept and one should be aware of that concept. What this concept envisages is that, let us say India has entered into a tax treaty with a particular country, country A, and after